to think about as we do carry it over. I will offer an amendment next week to either have these individuals supervised by the Bureau of Pardons and Paroles or Community Corrections, because one or the other, we ought to be able to get that job done. Commissioner Ward has asked us to carry over his bill on Bureau of Pardons and Paroles, the bifurcation of the Bureau and the board, and we're going to do that. I think that's all that we're carrying over to next week. So, Ms. Hall, we are back on House Bill 96. Are you ready? I know that's a substitute, but are you ready?
So, Mr. Chair, you know how I feel about substitutes, and so I really received it shortly. But what I wanted to say to you is that the substitute is based on the recommendation and the application process. So I know you and your members have not had a chance to look at it. And so, and I left you with the impression that this was not an intent to kill the bill. And I would like to and then I've been approached to have an amendment to what we have already. So what I would ask you to do, and I won't go into any further explanation unless you would like for me to, is to say, I think I'd be better carrying it over and allowing us to give you an opportunity to read through the bill, and then me an opportunity to get the amendment that the DAs are requesting, and we'll look forward to having a favorable report when we're done.
Thanks, Ms. Hall. I do too, and I appreciate it, and we'll certainly do that, and we will put you on for next week. And so, let me say this: Ms. Hall has been very good about carrying this over. I appreciate that. What I would like for us to do, if there are amendments to this bill, if there are things we need to do with it, let's get them in, get them done, get them to everybody. Not at the last moment, yes, so that we have an opportunity. Because I'm like you, I read these things too, Ms. Hall.
I appreciate that.
And so we'll do that. That's not a problem. Yes, sir.
I just wanted to commend Representative Hall. You have stood for what you believe in every day on the House floor about no last minute surprises. And it is so pleasant to see your character show and say, I'm not going to do this to somebody else either. So thank you very much for that, Ms. Hall. And I appreciate your kindness and your full servitude to the body.
I appreciate it. I like the upfrontness, and I'll tell you why. Because there was some vague threats last week about people that didn't like the bill were threatening to kill the bill. And so when I first left you, I left you thinking that they had certainly spoken to some of the members of this committee. But either way, whether they did or not, I also wanted to also challenge those individuals that I'm not a difficult person to work with, and I do try to follow the rule that I lay for myself. But I appreciate the fact that you've allowed me this opportunity, and when we return next week, hopefully we will have a bill that all of you can vote for and move forward with it on the floor.
Ms. Hall, thanks, and you do. You walk the walk as well as talking the talk, and we appreciate you.
Thank you.
We appreciate you.
Oh, may I introduce my pages?
By all means.
Well, let me let them. I'd like for them to tell you who they are. So come. Always. Yeah, I don't need that anymore. Madison.
Go ahead, ma'am.
Hi, I'm Madison.
Last name. Give me your last name and where you attend school.
I am Madison Saley, and I attend Grace Lutheran in Huntsville.
Thank you. What grade are you?
7th grade.
Hi, my name is Jacoby McGee. I'm 14 years old. I go to Monrovia Middle School. I'm in 8th grade.
Okay. We're certainly glad to have you all with us. Come back.
Thank you.
Yes, ma'am. Representative Keel, are you ready on this retirement bill? Thanks.
I appreciate those young folks having the courage to come up and stand in front of you guys. I've got a couple of middle schoolers at home, and I'm not sure they would have done the same thing, so I appreciate that. from you guys. This bill revises the way that that retirement allowance benefits can be garnished. And the only change, substantial change it makes is on page 2, it removes the line that says, the case has been assigned to the district attorney's restitution recovery division. In talking with my local DA and the DA's association, they were in agreement that removing the step of taking the levy to the district attorney's restitution recovery division would make the process more expedient and be more smooth.
Okay, does anybody have any questions for Mr. Keel? Yes, sir. Go ahead.
I guess 2 questions. I guess, is Social Security done the same way? Can you do the same thing on Social Security? Can you take their funds away?
I'm not sure. I'm not sure if you can do it through Social Security or not.
The second question, had a constituent call me. There was a recent case to come out of our Court of Civil Appeals that says if you do not make $1,000 a week, that they cannot garnish your wages. Are you familiar with any of that?
I'm not. This will not change the garnishment process other than it will remove that one additional step with the district attorney's restitution recovery division.
Okay.
And if I've got that step right, and somebody from the DA's office may want to chime in, but if they pay like $50 a month or something, it kicks the time.
90 days.
Irrespective of the amount that's owed, isn't that right?
That's right. So if they owe any amount, if they pay any amount this month, it delays the collection for 90 more days. And so what essentially happens is every 90 days they pay $50 and their wages are never garnished.
Any further questions? Is there a motion to give us, okay, yes, ma'am. Ms. Allman has a motion for favorable report. There's a second. Yeah, did you have a question or you seconded? That's what I thought. Okay, all in favor say aye. Aye. Any opposed? Thank you.
Thank you, Mr. Chairman. Thank you, committee.
Report. We appreciate this bill. Representative Starnes, you ready? Where'd you get? There you go. Obviously, you ready.
Good afternoon, Mr. Chairman and committee. I have the bill, House Bill 428, and there's a substitute that will be offered.
Well, let's go ahead and has somebody you got substitute, Matt? Go ahead.
Yes, sir. The substitute to 428 is provided in your packet. The purpose of this, and I'll let Representative Starnes explain mostly, but it just talked about the definition of mistreat. And at this time, I would offer the substitute.
All right, the sub is offered. Is there a second? All right, so the substitute is offered and seconded. Is there any discussion on this at this time? Sure, you can, but all right, all in favor of adopting the sub, please say aye. Any opposed? Okay, so now we're on your substitute bill. It's been adopted. And Mr. Wadsworth, you had a question. Go ahead.
I do. Representative Starnes, basically what it's adding is the term mistreat and then defining what that term means to your bill. Is that correct?
Right, yes, sir.
And it's without any physical injury to a child, because I think it says any intentional behavior that inflicts unnecessary or unjustifiable pain or suffering on a child without causing physical injury. How do we define, how is that being defined?
Well, this is not a new definition. It came from the Delaware Child Abuse Statute.
What is it? What type of intentional behavior that inflicts unnecessary and unjustifiable pain does this bill try to grab?
It was the striking, shoving, kicking, or subjecting them to physical contact. And we just kind of, that was the original bill, and that's our original intent. And we just kind of, we worked with the DA's Association, also DHR, and this kind of simplified the bill, but that's the reasoning behind it.
Would those items not cause physical injury to a child?
I've got an expert here that's going to address those issues. If you can just wait 1 second.
Okay.
Okay.
Go ahead. Who is it? Do you want someone to speak on that?
Yes, sir. I have C.J. Robinson. He's a district attorney for the 19th Circuit.
Okay, Mr. Robertson, where are you? Come on up.
Thank you, Mr. Chairman. If I can, I think I can respond directly to your question, Representative Wadsworth. Essentially, the child abuse statute in Alabama reads, if you torture, cruelly beat, willfully maltreat, that type of language, and it's a lot of times we think about sensational acts that get us to child abuse. You move past the definitions of things like harassment, striking, shoving, hitting, kicking. This really kind of is inspired out of a case out of our circuit from Prattville with the Journey Daycare situation, to where there were three individuals charged with over 40 counts of child abuse apiece. This occurred after an intern saw this behavior, reported it to the director. The director pulled the video. After reviewing this video for 30 days, these were children who were nonverbal. And when I say nonverbal, under the age of 2, from 6 months up to 13, 14, 15 months old. And these children, if they didn't take a nap, they were when I say shoved, I mean walk past the crib, 2 hands, shove the child flies across the crib, hits its head on the crib. Now, if that's something that you or I saw today, we would take our child to the doctor, be examined. You've got bruising, you've got other things that may happen. In this situation, and for the sake of time, I won't dive into every single count, but these children were grabbed and hit on the bottom of the feet 13, 14 times. And the intent is inferred from what you hear on the video. I want it to hurt. I want it to sting. They didn't think this camera was operational, the women working, and saying things like, oh, they'd fire us if we saw this. We're going to jail if they hear about this. So those type of things we saw. And in this day and time, especially with technology like nanny cams and things like that, I think we have an opportunity to act on behalf of children who can't go home and say, hey, I'm hurt. Hey, this hurt me. Whereas in other cases, if somebody could come home, and if you look at the definition of injury, a physical injury, you got a serious physical that I know has been amended over the years to shootings, and loss of limbs, things. But if you look at physical injury, it talks about substantial pain. So, we've overcome things in court when a victim is there to say, hey, this hurt, I got punched, bloody lip, busted nose, those type of things. Well, these children may have like a letter sent home that says we had I think it was called an ouchie letter or something, that something happened today. Well, the parents had no idea to dive that deep into it. But when you get this video, you see what's happening. So what we did, we drafted the original bill, we got with DHR, worked out some language to where we're all in agreement. They had some dependency concerns, and hence the agreed upon language with DHR was the substitute that's been entered. And that goes to inserting the language to say willfully mistreat. In our case, we had to proceed under willfully maltreat, which is typically an act of omission. There's some cases out there that are old that say it can be an act of commission, doing something. So in our case, what is clear, bone-chilling acts that when you watch on video, we had to endure multiple 2 or 3 weeks of hearings for that. Then the jury deliberated all about the definition. So this is to clear that up. Yes.
I appreciate it. Thanks for that explanation.
Any other questions for this gentleman? All means, yes, sir.
Okay, DA, I want to ask you about the application of this, the actual proving of a unjustifiable pain or suffering on a child without causing physical injury. How would it be proven in court?
I think the easiest way, or probably the most common way to prove that, would be things that we have now. Let's say Ring cameras, let's say nanny cams, mainly situations to where you still have to be a responsible person. That doesn't change that part of the statute. It's part of the normal child abuse statute. So this is not intended to try to curb corporal punishment. This is not intended to try to say this is, you spanked a child. No. Well, I've got 2 small children, a 5-year-old and a 3-year-old, and they get spankings a lot. God help us if I didn't spank them where they would be today. But my point being, this is not aimed at that. This is aimed at the unnecessary or unjustifiable pain. So if I've got a a 9-month-old that won't take a nap, and I walk by and there's a video or there's somebody in the room that says, I grabbed this 9-year-old by the back of the head and I lifted them up like I'm a professional wrestler and choke slammed them face down in the crib, that is unnecessary and unjustifiable pain. And under the statute, we fought for weeks for that to be something more than 90 days. Maximum punishment under harassment. We fought for that, and we were able to get a conviction, a felony of that. But I know there was many, many rulings that happened in our circuit that would be maybe not the same in different places in the state. So this is about taking out all this gray area here for these acts and trying to make it more simple. Now, this is still in conjunction with every part of Alabama law. You know, you've got self-defense. If in a custody case, some parents said, oh, they grabbed my child and hurt his arm. Well, yeah, because he was walking out on the road. I didn't want him to get run over. It's like, you know, self-defense, defense of another, all that is still in play. This focuses on unnecessary and unjustifiable pain. Like the kid wouldn't take a nap, so I shoved him across the room, or I hit him with a ruler 15 times in the back of the head, those type of things. But I think that probably the most common way that we'll have to prove this, because this is really coming from children who are nonverbal, is going to be through the use of video footage. You may have witness testimony, because if a child can come to us and tell us, hey, so-and-so shoved me today, they banged my head, then we're going to take them to a doctor and you're going to have medical documentation. But small children heal completely and they heal quickly. So if there's a delay in 30 or 50 days, like in our case, you're not going to have a medical person come in and say there is any injuries. Therefore, it gets you into a very difficult category of, well, the person who hurt this child, we're looking at maybe harassment. So you're looking at possibly 90 days, which is really not going to affect that person's ability to get a job at another daycare, which is what happened in our case, and different things. So it's kind of hard to say one way it'll be applied, but I think the most common way will be through audio and video evidence that we have a lot more of now than we ever did.
Any other questions? All right, go ahead.
Just a really quick question. In reading the definition, I just wondered, based upon the examples that you're giving, you're all describing an intentional act. And I just wondered why you chose the word behavior as opposed to act, like saying an intentional act.
I mean, I'm not sure there's really a major example or something I can give you as to why we chose intentional behavior as opposed to act. I mean, clearly when I say the act of doing it is I'm simply implying that you are intending to cause that act. But I mean, I'm not aware of any major discussions we have with DHR in arriving at that particular word in the definition.
Anything further? Do I have a motion? All right.
Got a motion to give it a favorable report.
Motion for, and a second. Any further discussion? All in favor say aye.
Aye.
Any opposed? All right, Representative Starnes, good job.
Thank you.
Mr. DA, thank you for coming.
Thank you.
Favorable report. On the, Mr. England, you ready?
Thank you for recognition. This is House Bill 229. We've it's been on the agenda for several weeks, and we've been carrying it over to do a lot of work to it. So before I get started, I want to say a couple of things. First, for me, this is one of those rare times in this building where the process works. And, you know, we all have like these beautiful, bright ideas that we think are perfect when we create the bill and we bring it here, and we get personally offended when somebody says, I don't agree or I don't like it, because, you know, we're always right. But there's those rare occasions where somebody could point out to you where there's some points of compromise. So I personally want to commend Russell Bedsole, because he has worked diligently through this bill through the entire process to get himself comfortable, and he offered some amendments that I think make it a better bill. I also worked with the AG's office, Catherine Robertson and Bennett Wright, to take the idea that we had and the group of people that we were trying to help and to pare it down into something that, while it doesn't give me everything that I want, Usually I can tell the process worked when everybody walks away a little upset or didn't get everything that they wanted. So with that in mind, the bill you see in front of you, House Bill 2229, there's an amendment that Representative Bedsole worked on with members of Appleseed to pare it down and get to the group of people who are incarcerated that we're trying to help. So as a sort of a foundation for the conversation, this deals with individuals who are incarcerated with life without parole. What this bill does is create a process for review for a specific subset of individuals that in the commission of their crime, nobody was harmed. In the commission of their crime, there was no sexual offenses, and it's listed there in the bill. Initially, there was Section 1 that sought to change the habitual offender law to remove nonviolent offenses. So in the amendment that you're going to see, or the amendment that you have, it removes Section 1. So we're not dealing with the habitual offender anymore. The amendment also it takes out the section where we had 15 and 50, and where Representative Bedsole worked it to 20 to 60, and it actually creates a process where anybody that received a final sentence of life without parole at trial court prior to May 26 of 2000. And the reason why that date itself is important is because, let me make sure I don't say this wrong. It was the effective date of the amended habitual offender law that no longer required LWOP sentences for Class A felonies with 3 priors. So that in and of itself pares it down to a group of people who are currently incarcerated that, well, now it's 2023, would have to serve 23 years in prison before they can get consideration for this. So also, so instead of saying you have to serve 20 years and be 60 years old, you'd have to qualify under life of the LWOP formula prior to March 26, 2000, and you would also have to serve 23 years in prison before you're eligible. Also, working with Representative Bedsole, he had a concern about victims, so we added a section which would be on line 123 on page 5. It said the court determines a hearing is necessary. The judge shall give considerable weight to any objection made by the victim. And then also the clerk of the court shall notify the law enforcement agency that has investigated the crime for which he or she was convicted. So the victim's position on whether or not this individual should be released should be given a considerable weight, which means more than the other circumstances. And also the clerk shall notify law enforcement that was responsible for the arrest that triggered the life without parole. Also, in talking to Representative Bedsole, one of the things that he was concerned about was also the use of a firearm. So this also requires the judge to replace line 136 on page 5 with the following, and says, whether the individual used a firearm in furtherance of the offense, if so, the judge shall give considerable weight to this fact. Then on page 5 and 6, it says this section is if a previous motion for a reduction of sentence under this section was denied. So this gives everybody in this group one shot for review. And if you're denied, that's it. There's no appeal. There's nothing else. At that point, if the judge denies your request for relief or reduction in sentence, that's it. Also, on lines 154 on page 6, it says be granted a hearing within 60 days of the court receiving the notice, and that's just procedural. And the very last thing that was added, and this was working with the Attorney General's office, is that this section that we're creating shall be repealed 5 years after the effective date of the act, adding this section.
So it's got a sunset provision in it. So that means that the group of people that we're talking about who are serving life without parole, they get one shot at it. If they don't get it, if they're denied, that's it. And after 5 years, the section is repealed. So we're not creating any additional people. There won't be anybody that grows into consideration for this. After 5 years, that particular group of people won't grow, and then eventually this procedural itself will go away. So that's what the amendment does in a nutshell. I'm here to answer any questions.
And Mr. Betzel, do you have anything to add to that?
Well, I think Representative England did a really good job, and I just want to, I'm thankful to be a part of that process. We saw an opportunity here with a bill that certainly in its original format wasn't something in my position as a career law enforcement professional that I could see progress the way it was. However, we did see something that we had a path to maybe helping out those individuals in that very, very narrowly defined areas. So certainly the ideas I offered, I think many behind the scenes took those and did an even better job than I intended. So certainly these amendments, I think, do a lot to giving this bill an opportunity, and I'm certainly pleased with the work that has been done with it. And Mr. Chairman, if you're accepting his, if not, I would like to make a motion that we accept this amendment.
Okay. Do you have a question on the amendment?
On the amendment, and I appreciate both the hard work that you guys, Representative England, your tenacity on this, and Representative Bledsoe, your work on this. One issue that I would ask if you would consider an amendment to the amendment on line 42, grant the hearing within 60 days of the court receiving. I know you've moved it from 30 to 60. Is there any chance you'd be willing to go 90? I've been the prosecutor that's had to go through this. They've got to find files that are 25 years old to be able to try to find and locate the victim and make sure there's a process to get through. I'm not trying to stall what you have, but I know how much of a grunt work that is to go find these files. And if you get a motion to say you have to have the hearing within 60 days, it's tough.
Fine with that.
So I would move to amend the amendment to 90 days.
Let me ask you this, Mr. Simpson, as we're getting into this, be granted a hearing. Now, I have seen statutes where we said be granted a hearing means to set the hearing as opposed to actually have the hearing. Which I guess, Mr. Betzel, Mr. England, which do you mean here? Because, like I said, I have seen things that talked about doing things, within a real short period of time, and it was set the hearing during that time as opposed to conduct the hearing during that time.
And I hate to interrupt, the way that I read that, any motion for reduction in sentence shall be granted a hearing within 30 days. So you're saying the hearing is granted within, 30 is the original, but 60 in the amendment. The hearing is granted within 60 days. So, I read that as you have to have the hearing within 60 days. You have to have the hearing.
Okay, that's fine. That's fine. I just want to talk about it for a second.
Mr. Chairman, is that, I don't know how complicated, I guess we can draft it real quick, but if not, that could be something perhaps you would entertain to be done on the floor, but do you already have that taken care of?
I've got it procedurally. It basically says on page 2, the amendment to HB 229 replace 60 with 90. So it's an amendment to the amendment. Can we do it that way?
Sure, but let's do this. Before we amend the amendment,
why don't we adopt it?
Let's adopt the amendment.
And then
is there a motion?
The bill.
Okay. All right, I'll let you. But there's a motion. There's a motion to adopt the amendment. All in favor of that, please say aye. Any opposed? Okay, now, Mr. Wadsworth, go ahead.
Is with the amendments, is there a age factor
No.
in this bill?
You would have had to have been convicted before 2000, and you would have had to have served 23 years before you're able to even be considered for review. So you're likely looking at somebody that's probably closer to 60 years old, but at the very least 55. But you've already, because you got to think about it. You could be in your 20s and get convicted, but you still have to serve at least 23 years. So you're going to be probably over 50. And then by the time you get to you avail yourself of this review process, you're probably going to be closer to 60 years old.
Thank you, sir.
Okay, Mr. Simpson, I think we're at the point where we could accept, if you want to make a motion to amend, and I'm just going to call it amendment number 2, which would move it from 60 days to 90.
I would make that motion.
Mr. England, to you. What do you say?
Second.
Thank you. Okay. So I'm going to assume that's what we would call a friendly amendment.
Yes.
And so all in favor of the amendment number 2, please say aye. Aye. All right. Any opposed? Okay. So Mr. England, it is back to you as amended twice.
If there's no questions, move for, I guess I can't do it.
Oh, you can. Sure.
Okay, sure.
You're a member of this committee.
A favorable report is amended.
All right, Mr. In a second, we got a motion and a second to give this bill a favorable report as amended. Any further discussion? All in favor, say aye.
Aye.
Any opposed?
Opposed.
Nope. Favorable report is amended. Thank you, Mr.
Thank you.
Appreciate it very much.
Again, thank you for everybody for your patience and your mercy. Thank you.
Yeah. That is the shortest meeting in the history of the Judiciary Committee. Let me say this to y'all.
That diagram has David Fogger getting here late in the middle of it.
They do. That comment's well taken, and also when Brandy saw you and Russell agreeing, she got all choked up. So better things are coming. In the morning, I'm going to ask the speaker to give us a moment to have a special call meeting. I think if y'all do not have a copy of this next bill, I'll make sure you get it before you leave here today. But it deals with it deals with facial recognition on pornography. So this is Mr. Robbins' bill. We just got it too late to put it on here today to give the requisite notice, but I'd like for us to talk about this in the morning. With that understanding, ladies and gentlemen, we are adjourned. Thank you.